Hey, everybody, and welcome to Thursday night. Hello, all. Welcome. Thursday night here on the Consumer Warrior YouTube channel. I am John Skiba. I am a bankruptcy attorney and I like to call myself a debt defense attorney to help people who are getting sued by debt collectors, junk debt buyers, original creditors, all those kinds of people. And I'm here in the state of Arizona. And I founded the Consumer Warrior YouTube channel to provide tips and strategies and ideas and really just some hope to people who are being sued by debt collectors or dealing with other debt problems like wage garnishment, bank levies, all those kind of horrible things. That there is a way to put a plan together to be able to kind of get through this and deal with it and stop losing so much sleep over it. So, like I said, I am a licensed attorney in the state of Arizona. However, I'm not licensed anywhere else, so I can't give any legal advice. Watching my YouTube channel doesn't create any type of attorney-client relationship. We can be friends, but I don't represent anybody. And I highly recommend if you have a legal question, particularly if you're not in the state of Arizona, to find an attorney in your state. I don't know all the laws in every other state. I'm just some dude on YouTube talking, so take that for what it's worth. What do we like to do each and every Thursday evening is if you have questions to go ahead and put them, if you're on YouTube, put them in the chat section. I'll put them up on the screen and we can talk about them. I can tell you some of my experiences, maybe point you in some directions for resources and see what we can do to help you out. Before I jump into that, I mentioned this last week that I have started this new Consumer Warrior community, which is a kind of a deeper dive in some of the topics that we discuss here on the YouTube channel, both in my videos and in the weekly live streams. I'm also going to have some content that's specifically for community members to access it. So like, for example, coming up this Monday, we have a masterclass on excluding junk debt buyers' documents as hearsay. I'm going to jump into the rules of evidence and how you can do this if you're facing a junk debt buyer or even an original creditor in a trial or debt collection type setting. And then we're going to do that via Zoom on Monday at 7 p.m. And then on the 24th, a week later, I'm going to be doing a masterclass on how to cross-examine a witness. These are things I don't go into a lot here just because it's more kind of next level stuff, but they're very important skills that you need to have if you're going to have, effectively representing yourself in a debt collection lawsuit. In the YouTube chat section at the top, there's a link. You can go there, sign up, and become a member of the community. There's additional things and trainings I'm going to be providing, additional resources. Plus, you get a percentage off of all of the tutorials that I have, the online tutorials if you're a member of the community. So go ahead and check that out. So I was going through the comments section on my channel, and I found a couple questions I wanted to jump into. This one, it actually kind of goes along with what I was talking about, some of this advanced level training. This person asked, what kind of due diligence can you do to make sure that a particular case is still good law? So the idea behind this one, and to understand how the legal system works, there are different sources of law. There's like the statutes, like in Arizona, the Arizona Revised Statutes, the legislatures that they pass, and those are the laws. But there's also case law, which is the rulings that the courts issue when they're interpreting those laws. And case law can be, if it's an actual opinion of the court, it can be binding. To make things even more complicated, the judges and the courts will issue what are called memorandum decisions. They're not binding. They don't create what's called stare decisis, which is this essentially a controlling an opinion. We saw this on the national stage this summer when the U.S. Supreme Court overruled the Roe versus Wade decision. There's a lot of there's the political issues obviously around that, but in the legal circles, there's also this question of, well, what about stare decisis? What about this principle of precedence that the higher court issues a precedent and then the lower courts have to follow it? So that's in all areas of the law, including this kind of, junk debt buyer debt collection law. And so the question here is, how do we know if the case that we are dealing with is still good law? To go back to this summer, so Roe versus Wade, it was overturned by the Supreme Court. So if a party were litigating a case and trying to use that as a basis for why they wanted the court to rule a certain way, it's no longer good law. So there would be an opinion that has replaced that, which is the opinion that's there. Maybe I should choose less controversial opinions, but it's just a good real world example of how these legal opinions, how they have controlling precedents for the courts that are lower. And so if you find yourself doing some research and there's some case law out there that you want to use in your debt collection case, you need to know if it's still good law. Now, it's not super easy. I'm going to tell you, if you're not an attorney, to find out exactly if the case law is still good law. Attorneys, we use a program called Westlaw, which it's this huge company, and they go through all these cases, and they have, I mean, literally they put little flags. If it has a red flag on it, it means it's been overturned, or there's some kind of negative information in there from another court, or if it has a little green flag, you know that it's still a good case. The places where you can go, and I should say Westlaw is crazy expensive. It's expensive for attorneys, to the point where there's some other companies really trying to disrupt that. One place you can go is Google Scholar. If you go to Google Scholar, whatever it is, .com, I don't know if that's the actual address, but you can Google Scholar. You can actually research legal opinions and case law in there. Now, it's not going to have the little red flag or the green flag. And so that's where it becomes difficult, because you really have to start doing some research and looking to see if it's the most current, up-to-date stuff. That being said, you can have an old case that's still controlling law, but maybe if you find something that's more up to date, if you see an opinion from 2021 or 2022, you can go through there and see what the law is in your state and how courts have been interpreting it. So that's one place. There's another company called Case Text, Casetext, Case Text. Before I worked here at my law firm, Jackson White, I use Case Text all the time. I believe they have some just kind of free versions of it, and they also have some paid versions, and it's super cheap. So even if you wanted to sign up for a month, you'd be able to do some research. They have this really cool AI feature where you can take like the brief from the junk debt buyer, you can scan it, upload it, and it gives you all the case law that's to fight it, that opposes the case law that they provided. So it's kind of a cool feature. That's kind of deep dive into kind of how you can do it. But Case Text is probably your best bet if you're looking to try to be able to find out if a case is still good law. Google Scholar could be a good tool as well. This person asks, do I need to disclose property owned in a foreign country in my bankruptcy case? The answer is yes. If you are, no matter if you're filing in Chapter 7, Chapter 13, whatever it is you're going to file, you need to disclose everything, period. I get this question a lot about cryptocurrency. If you have cryptocurrency, yeah, it's hard to find. Do you have to disclose it? Absolutely. And I can tell you, I've shared in videos before that Coinbase, which is one of the big, I don't even know what you call it, a wallet for a place where you can keep or buy and sell cryptocurrency. They actually have a page on their website devoted and for bankruptcy trustees and how the bankruptcy trustee can search for cryptocurrency. So it's a felony not to disclose assets in a bankruptcy. So it doesn't matter where on this earth they are, or on the World Wide Web, or on the ether. When it comes to cryptocurrency, you got to disclose everything. So, all right, let's jump into some questions. We got Al here. Hey, he says, yep, we need to get more members and subscribers to the Consumer Warrior community. Thank you. Al's one of the first members of that. And it is true. Truthfully, the community is only going to be as good as the people who are here. That's why the weekly live stream is so, I think, awesome and helpful, is because there's a lot of different people with different questions coming from different areas of the country. If you go in, see what it's like. It's a paid community, but the first 30 days are free. So you can jump in for this next month, get some of these new trainings we're doing over the next couple of weeks, and just see if it's something that you want to do. And if not, you can bail on it. But yeah, so go ahead, please check that out, and at least just try it out for 30 days. And let's see if we can help each other out a bit. All right, let's see here. Let's see what CJ has to say. She says, I know you can't answer questions that are not specific to your state. great. You're listening to my intro each week. But if mediation didn't work, can you still ask for arbitration? Yes. So if you go through the mediation process, where mediation is where you're trying to come up with some type of settlement agreement between the parties, yes, you can absolutely ask for arbitration at any time. If you look and read specifically the arbitration clause um, in your terms and conditions of your credit card, it will tell you. Usually, in most of them that I read, it says that you can actually ask for arbitration right up to the point where either trial started or judgment is entered. So, I mean, my recommendation is do it sooner than later, but you can ask really at any time, and the court should grant it. I say that sometimes they don't, and that's a whole other thing why sometimes they don't. But that's something you can do at that time. So, all right, let's see what Mitch has to say. Had a strange thing happen this week. After 3 years and 8 months of not being on my Bank of America checking login, a Bank of America credit card balance appeared again, asking me to make a payment. Concern or no? I would be concerned if it were me. Because, so I guess the question is, did you have a credit card balance? I would be more, I would check my credit report. I mean, the fact that it's showing up on your login, I mean, yeah, I mean, it tells you something's happening. Something, whether they went, because Bank of America, they usually don't sell their debt. So it's telling me that they're kind of revisiting it. You may want to see if it's outside the statute of limitations before you make any payments on it. Like in Arizona, if it's been more than 6 years since you made a payment on that, it's unlikely that it's a collectible debt. So I would definitely do a little bit more research into that. So, all right, let's see here. Tiffany says, good afternoon. How do you go about deposing a person for the plaintiff who has the affidavit stating that they put the documents together for Midland? This is a good question. And I am going to be I'm in the process. It's on my to-do list of putting together a tutorial on how to take a deposition. Depositions they're essentially interviews where the other side is under oath. And you have a court reporter there typing everything down. And usually nowadays they're done via Zoom or they're recorded via video. As far as how do you go about deposing them, if the lawsuit has been filed, the rules of civil procedure in most jurisdictions will allow you to provide what's called a notice of deposition. And you can notice up the deposition of a specific person. So like for Midland Funding, if there's an affidavit and there's a person on there, you can notice up their deposition. You literally you pick a date and a time. It's usually got to be at least 2 weeks to 30 days out. You got to give them notice and send it over there. You're going to be responsible for finding a court reporter, hiring them to be there. Often what I see with debt buyers, because Midland is either in Minnesota or often out of San Diego, you're going to end up doing it via Zoom. I don't have a huge problem with that. Pre-COVID-19 pandemic, I can tell you, I pressed a lot more for in-person type things. The courts they don't care anymore. They're going to let everybody do everything via Zoom, mostly because it's kind of crazy. The courts, at least in Arizona, are largely going via Zoom on everything. So, but you can do the Zoom deposition, and it's a good opportunity for you to really quiz them. Another kind of little plug for my course, or the Zoom call I'm going to do on Monday night if you join the community. We're going to talk about some of these rules of evidence, particularly the hearsay issue, because that's where you can really drill down and kind of stick it to them a bit to show that they don't know what they're talking about. And you could do that in the deposition as well. All right, let's see what Mr. Lowrider 3 says. Should I hire a lawyer on a $3,000 debt collection or try to settle with them in court? What's the advantage of hiring a lawyer on a debt collection lawsuit? Can a lawyer fight to make that debt disappear? Well, you're asking a lawyer. So I am a little bit biased here. But I can tell you this. Anytime someone calls me in my office and the debt is less than $5,000, what I often tell people is a good approach is to reach out to the other attorney and say, look, I've met with an attorney. It's going to cost me X amount of dollars to hire an attorney. I'll pay you that instead. Otherwise, I'm going to go hire this attorney. Now, obviously, it doesn't make sense. like a $3,000 debt, I can tell you if you were to call my office right now in October of 2022, if that would be in the justice court system, my office charges $1,500 to handle justice court cases. So would I say it's worth hiring an attorney? I would definitely push you to try to settle that before I would let someone retain me to handle a $3,000 case. I mean, 3 grand is 3 grand, but I can tell you that's really why I created the YouTube channel. That's why I created the online tutorials and the templates that I have, is because I can't tell you how many people I've been contacted by who are getting sued for much less. I've seen lawsuits for as low as $500 for Midland in particular. And it just didn't make sense to have an attorney involved. And so I tried to create some of these things that will really give you a leg up to try to resolve it through, whether through settlement or fighting it yourself. So for a $3,000 one, I mean, that's the approach I would recommend. I mean, if you were calling me in my office, I would say, look, instead of paying me $1,500, go call the attorney for Midland. And again, settlement discussions in civil cases are not admissible in court. So it's not going to harm you to reach out and say, look, I'll offer you $1,500 to make this thing go away. So that's probably what I would recommend you do right there. So, all right, let's see here. The best future me says, I received a letter debt from a new servicer and also stating they may not transfer title to my account to a subsequent transferee. The servicer anyway assigned and transferred it to LVNV funding. Should I file a motion to dismiss with prejudice? Colorado automatically assigns mediation. Should I continue mediation? See what LVNV says, explain the letter, then file the motion. So you're saying that the debt has a new servicer and is also stating they may not transfer title to my account to a subsequent transferee. I would need to see it a little bit. Oh, there's another one here. It says, do I have to respond to a disclosure statement? If he has the exact same documents as me, can I use their documents against them? I'll answer that question after I go over the first one. So I would need to know a little bit more as far as if you're saying that the new servicer, that they provided you documents that says that the new servicer is not allowed to transfer it to a subsequent transferee, but then the servicer assigned it to LVNV funding anyway. I mean, that would be a basis for a motion to dismiss for sure. So, and you know, whether the court would dismiss it with prejudice or not, that's going to be obviously up to the court. But I think it's worth a motion to dismiss if it's something where if the debt was non-assignable or non-transferable and then they did it anyway, that could be a basis for lack of standing by LVNV. So I don't know if a court, even if the court didn't grant it, it's definitely something, if you went into mediation, you could bring up and try to push for kind of a lowball settlement offer. So I think you're going down the right lines there. To your last question, do you need to respond to a disclosure statement? In most jurisdictions, the disclosure statement is a requirement of the parties, and there can be penalties if you don't disclose things properly. So, for example, you're required to disclose your defenses, and if one of your defenses is, hey, they don't have standing because this debt was non-transferable or non-assignable, you need to put that in your disclosure statement. Otherwise, you could be barred from using that defense down the road. So, yes, always do a disclosure statement. Better safe than sorry. And yeah, if the documents are exactly the same, yeah, you can use their exhibits against them. But I would still do a disclosure statement, just because the whole idea is that there is no trial by ambush. You can't. You must respond in a or provide enough information so that they can put together their case that they have. All right. Jeff Baxter says, hello. When it comes to business debt, are debt buyers still required to validate debt first before sending a lawsuit? Do they have to wait for a certain period of time before filing? Jeff, this is a good question. So the verification process or the validation process of debt, that stems from the Fair Debt Collection Practices Act, the FDCPA, federal law that governs debt collectors. But as you notice what I said right there, it governs debt collectors. And it also, in order for it to fall under the purview of the FDCPA, it has to be a debt that was for personal purposes or family purposes. It can't be a business debt. So there's even been cases out there where someone has a personal credit card, but the debt or the charges on it were totally business. That some courts will say that the FDCPA doesn't apply to that. So if it's a business loan of some sorts, then no, they don't have to do the whole FDCPA authentication validation of as far as providing you copies of the debt before they file suit. Or if it's an original creditor. That's it's so screwy to me that the FDCPA doesn't apply to original creditors, because essentially they can do what they want. If Bank of America has a loan and they want to be annoying on the phone, they can do that. I mean, there's some state versions of kind of the FDCPA that would help it out, but that may help you out, but the FDCPA is not going to provide you those same things. Hey, CJ, thank you. I appreciate that for your support of the channel here. All right. Let's see here. Let's see what we have here. It says, I'm in the middle of negotiating a case, but I might have to go to another state for some time. Can I file a motion informing the court that I will not be available? So, I mean, a lot of it will depend on how the court communicates with you. A lot of times these days, courts only communicate via mail. If you're going to be somewhere for quite a while, and what you need to do is have do a change of address with the court so that they mail you things. And you need to provide not only to the court, but you need to provide it for the attorney for the other party. And so it could be something, if you're going to be for a few months, a temporary address, whatever it is. I mean, you could always, I guess, go out and get like a PO box or like like those UPS mail boxes or something like that for a couple of months. But you usually have to file what's called a notice of change of address with the court, and then provide a copy to the other attorney so that you give them proper notice there. So, all right, let's see here. Abe says, can you settle for half the amount owed and ask for a 1099-C for the remaining balance if you're already summoned? So the 1099-C, what that is, if you settle, if a creditor forgives a debt, and last time I looked, it had to be more than $600. If they forgive the debt, then they can issue you a 1099-C from the difference of the amount owed, and then they minus out the amount forgiven. So if you have a $10,000 credit card and they agree to settle it for $2,000, you pay them $2,000 cash to be able to get this thing settled. They can then issue you a 1099-C, the creditor can, for the $8,000 that they forgave. And then you have to count that as income on your tax return the following year. Now, there are ways around it. And, I don't give out legal advice on my YouTube channel, and I certainly don't give out accounting advice. But I can tell you, if you're technically insolvent, if your debts exceed your assets, there may not be any liability on that. And so the 1099-C may not be a problem. And truthfully, I mean, I always say it's better to pay taxes on $8,000 than it is to pay $8,000. So you're still getting a discount. But particularly if there's large amounts that you're settling, if you're settling, if there's a $50,000 credit card and you're settling this thing for 10 grand, you could get hit with a 1099-C for 40 grand. And all of a sudden that's going to make a pretty big difference in your overall tax liability. So definitely something, to look at the total amount of debt that's owed, how much is being forgiven, and then maybe even talk to your accountant before you actually settle out the claim. James says, any suggestions on how to find an attorney in another state? I'm having trouble finding an attorney that specializes in consumer protection. Yes, my recommendation, if you're looking for someone outside the state of Arizona, because if you're in Arizona, obviously you're going to give me a call, would be to go to the National Association of Consumer Advocates, NACA, N-A-C-A. I believe their website is consumeradvocates.org. I'm a member of NACA, and they have an attorney finder feature there, and you can actually kind of pick the area of law, and it's nothing but consumer attorneys. And you can put your zip code in, and they'll give you a whole list of attorneys in your area who do what I do. Who do consumer. In fact, to be a member of NACA, we have to sign this big pledge that we don't represent creditors and that we're competent in this particular area. And so, again, that's National Association of Consumer Advocates. And again, the website, I believe, is Consumer Advocates, plural, consumeradvocates, plural.org. So go ahead and check them out and see what you can find. All right. Maria says, received my meeting of creditors. So this is a bankruptcy meeting of creditors for November, Chapter 7 bankruptcy. Kept my mortgage and car, but my mortgage was closed on my credit report. Shows a zero balance, reporting current, but no payment history. All right. Maria, this is like the bane of mine, every bankruptcy attorney's existence. And it's rough for clients as well, because so what happens here is, and this gets very confusing with secured debts in a bankruptcy. Secured debts is anything with collateral attached to it, like a property, like a car, home loan. Technically, when you file for bankruptcy, your debts are zeroed out. And so that's why all of a sudden you'll see on your credit report, if you go through a Chapter 7 bankruptcy, all of your credit cards are zeroed out. The claim's still, the creditor's still there, but they're zeroed out. There's no money owed. Well, with your secured debts, that's also true. They're zeroed out and they're showing that there's nothing owed. But there's two parts when it comes to secured debts. So like with your house, there is the promissory note that says, okay, you owe this money to buy this house. And then there's something called a deed of trust. And that document ties the two together. So we have a secured debt. The promissory note is secured by your property, by your home. And if you don't pay your mortgage, they can then come in and foreclose on that deed of trust, hold a trustee sale in Arizona is how they do it, where they can take your house back. And so in a Chapter 7 bankruptcy, technically that promissory note, it zeroes it out. It says there's no money owed on that. However, the reality is there's still a deed of trust on the other side. And if you don't pay your mortgage, they're going to foreclose on your house. So the confusing thing is, what the creditors say is, look, there's this law called the Fair Credit Reporting Act, the FCRA. And we want to, the law requires that if they're going to report on your credit report, they've got to do it truthfully. And so they're saying, look, technically on your mortgage there or on your car, there's no money that's owed on it. But we have this security interest in your vehicle. We have this deed of trust, or we have this lien on your vehicle. And if you don't pay your mortgage and if you don't pay your car, we're going to repossess the car. We're going to foreclose on the house. So I always tell everybody, if you go through bankruptcy, there's no such thing as the free car and the free house. You must continue to make your car payment, continue to make your house payment if you want to keep your house, if you want to keep your car. However, it just becomes confusing and frustrating when you look at your credit report, because the information that's on there is going to show zero. And not only that, if you do not have an approved reaffirmation agreement on your house and on your car, they're not required to report anything, good or bad. It's just as if it's the loan that time forgot. There's nothing on there. And so the other difficult thing, and this is a rant, because this becomes a constant one. It's difficult to explain, and it's difficult to explain quickly, and it just doesn't make a lot of sense to people. But so a reaffirmation agreement in a bankruptcy it's another contract. After the bankruptcy is signed, excuse me, you sign this reaffirmation agreement saying, hey, I'm going to continue to pay my loan. The courts have to approve it. The courts don't want to approve those reaffirmation agreements in a lot of situations, because if they do, and then something happens down the road and the car, you can't make the payment, not only can they repossess it, they can sue you for the balance. If the court doesn't approve the reaffirmation agreement, then they could take the car back if you stop making payments on it, but they can't sue you for the balance. So a lot of times in Arizona, the judges' practices is they don't approve the reaffirmation agreements, and they put you in a position where you're just not getting any information at all reported to your credit report about your on-time payments. So you're making all these payments, but they're not being reported. The other issue is with a mortgage loan, you're not required to reaffirm those. I have never seen, in 20 years of doing this, I've never seen a bankruptcy judge even consider reaffirming a mortgage loan. So that may be different in other states, but I can tell you in Arizona, it's not. And anyways, I could go off we could spend a whole hour on this. So Maria, what I'm trying to say here is what you're seeing here is completely normal. You didn't do anything wrong. Just keep making your car payment, keep making your house payment, and you'll be able to pay those things off. It's just it's this perfect storm of all these statutes and laws combining that creates a big stinking mess. All right. Chris says, I would like to settle some collections. Could you give me some tips on how to approach them? and what to avoid as to not restart the clock on the debt in the event that they don't accept my offer. So when you are reaching out to do settlement, usually the debts are going to have to be past due. I can tell you that. Sometimes I'll see creditors will come in and offer something if you're current, but usually if you're current, they're like, well, they'll offer you something like, well, let's give you lower interest or something like that just to get it back on track. If you're offering settlement, a lot of it will depend if the original creditor still has the debt or if they sold it to a junk debt buyer. Junk debt buyers like Midland, like we've talked about, Portfolio Recovery, Unifund, LVNV, Resurgent, Capital, all these guys, they don't pay a whole lot for these debts. There was an FTC study said most debt buyers pay 4 cents on the dollar or less. And so they're often willing to negotiate at a much lower rate than other types of original creditors are who, they're fully in. They have a complete loss on it if you don't pay it. And so if a junk debt buyer has it, I usually say you can get settlements between 10 and 35% of the total amount that they're claiming is owed. Original creditors, it's going to be closer to 50 to maybe even up to 75% on the total balance that's owed. It also depends a lot on your personal background. If there's hardship information, if there's, some situation with jobs, family, medical issues, those types of things, those can influence settlement dramatically. And so those are always important to bring up. I always say if you're dealing with another attorney or you're dealing with the creditor themselves, your job, if you're trying to settle the debt, is to make your best case, help them to make essentially their best case as far as to why they should accept your settlement offer. At the same time, I always say don't provide bank statements, pay stubs, all that. All they're doing there is trying to put together a roadmap to your assets, and then they can sue you and garnish wages, bank accounts, all that kind of stuff. So as far as restarting the clock on the statute of limitations, I can tell you that can be a little bit state specific. The Arizona Supreme Court issued a great opinion here a couple of years ago that really gave some clarification. In Arizona, they say the statute of limitations does not restart unless you acknowledge the debt in writing. You send them something saying, yep, it's my debt. I'm going to try to get it brought current. Or if you bring the debt current through payments. And so like in Arizona, if you have a credit card and you're behind on it, you haven't made any payments for 6 years or 5 years, the fact that you go and make a $25 payment on it, that doesn't restart the statute of limitations. You would have to bring completely current the past due payments. So those are the biggest issues and the biggest areas in some states with restarting the statute of limitations. And there's case law that, interpreting that's a little bit different, whether it's they're paying, maybe a partial payment could restart the statute, acknowledging it in writing or bringing a current. Usually just reaching out and trying to resolve it with a settlement proposal does not restart it, but I don't know that for sure in every state. So you got to be a little bit careful there. So, all right. Triple Crown says, I have a claim in bankruptcy for $60,000 in medical bills. Should I wait until collections hit my credit report or file now? I'm interviewing, so I want to stretch it out so I can get hired, background check done first. If having a bankruptcy in your credit report is going to limit the jobs you're going to get, I'd probably wait, get the job first just for that alone. Plus, medical collections in particular, they have special rules as far as when they actually show up on your credit report. I believe the new statute is that they have to be at least 6 months past due before they can even report it. And then if you get them cleaned up, if you settle a debt collection that's medical related, they actually have to delete it without you even asking. They just have to delete it. So like a credit card, if you're 30 days late, they can report it immediately. Medical collections, I believe, is 6 months. So it may take a little bit longer for that to even hit your credit. Truthfully, it's not going to make a huge difference. If you've decided to file a Chapter 7, to me, the overarching thing that's going to affect that decision is the job hunt, because it's not going to, as far as credit score goes, once you file the bankruptcy, it's just going to, pull the grenade. It's going to blow the credit report up, but you'll recover from it, but it is not going to matter either way. So, hey, thank you, Best Future Me, for the support today. I really appreciate it. All right, let's see here. See what Lifestyle says. What's my opinion on officials that serve you with the business card and no summons, papers telling you the court date and who is suing you? You need to check in your, and what this is sometimes process servers will come by and they don't get you home. And so they'll leave a little card essentially wanting you to call them so they can come back and drop the paperwork off. And the reason is in most jurisdictions, service of process of a complaint and summons, they have to come by and put it in your hand. Unless they get an order from the court allowing them to do it some other way, they generally have to actually give it to you in person. That can vary from state to state. And even Arizona, if they're serving someone from out of state, they can often do it through mail. So it's something you got to be really careful with. But that's generally why they're leaving a business card, is because they want you to reach back out to them so that they don't waste their time, just keep coming over and not having you there. My opinion, and this is an opinion I get yelled at all the time on YouTube and everywhere else, is I always say don't dodge service. Just get it. If it were me, I would call them up and say, yep, bring it by. Let me deal with it. Because it's where I see the most default judgments entered is when people are trying to, skate around and avoid the process server. And then the court gives them an alternative service order. And then they end up ending it with the default judgment. And then it's a big mess. You can deal with it. You have a lot more leverage, and you may have some really strong defenses that you can put forward if you deal with it head on. So I say, just get it and, deal with it that way. So, all right, let's see here. Jeff had one more. Last question. When it comes to business debt, if the original creditor has an arbitration clause, does the debt buyer have to abide by that as well? Yes. So the debt buyer, and this is where you can use this against them, and why it kind of blows my mind when judges deny motions to compel arbitration. The debt buyer is coming into court, and there's no disagreement that they didn't loan you any money. You didn't agree to pay them any money. And so, the issue of standing, and they always say, no, judge, we just stepped into the shoes of the original creditor. We are them now. And that's why we can get payment. That's why we're entitled to payment. We can sue this person. They are bound by those terms and conditions as well. If the debt buyer is going to take that position, that's why they're here, and that's what gives them the right to even be in court and to sue you, then they have to take the good with the bad. And they think that, obviously, they're thinking that the bad here is that they're going to be bound by those same terms. So absolutely, they should be bound by that. Hey, Mitch, thank you for that. I really sincerely appreciate that. All right, let's see here. Max, how much percentage do credit cards usually ask for in court granted arbitration? So if it's arbitration, and this is maybe a mix-up of terms, arbitration is kind of like an informal trial. Like in Arizona, the courts actually can do what's called compulsory arbitration for cases under 50 grand. And we often talk about in the channel about compelling private arbitrations, where you actually hire a company like AAA, the American Arbitration Association, to handle your case. Those ones, that's where it's kind of an all or nothing. You either win and pay zero, or they win and they get the full balance. If you're going to mediation, where you're going to try to find some middle ground, like I said, percentages depends on whether it's original credit, or if it's original credit like Chase. Although Chase usually sells their debt, but if they're coming after you in their actual, it's actually Chase, you're probably looking at least 50%, could be as high as 60 to 70% of the total balance. Those cases, I usually set up payment plans with something called a stipulated judgment. So, all right, let's see here. Do a couple more. Sasha says, I responded to a summons for a debt in my old state asking for verification of debt. They changed the attorney and sent my notice. What are my next steps? So if you've actually filed the answer to the court, then the next steps, it usually goes into a disclosure period where you've got to exchange disclosure statements, discovery. You're really going to want to check, if you're not in Arizona, I don't know the exact process. It's all similar, but you want to look for the rules of civil procedure for your court. Maybe go to the court's website. Often they have resources. They'll kind of give you a roadmap of which way to go with it. So, all right. Let's see what Elizabeth has to say. Under an account stated theory, can the debt buyer use the original creditor statement to stabilize the new debt that they said they now own? What are the best defenses for an account stated? So this is a good question. So when the creditor files a complaint with the court, they generally will have different claims or causes of action. They may say, okay, this is a breach of contract. And then another one they often use is account stated. Now, breach of contract, I can tell you why they use account stated. So breach of contract requires offer acceptance consideration. They've got to be able to show that there was an offer, that you accepted it, and then it was supported by consideration or some money is exchanged between the parties. Usually, the fallback claim is an account stated if they don't think they can prove the contract. And the reason why they run into problems with it is because it's not like the old days. If you're older like me, they used to send you a credit card application in the mail, and you literally sign the credit card application, put it in the mail, and then you'd sit there and wait for weeks to see if you got approved for this credit card. And so, but they had a written agreement, something that you signed. Now it's all done online. Sometimes there's written acceptance, sometimes they're not. And so it makes it a little more difficult for them to prove breach of contract, particularly for a junk debt buyer, if they didn't get all those documents from the original creditor, which they often didn't. So in a situation like this, they'll use the account stated. Now, what the account stated theory is, it's essentially where they're trying to prove their case through a course of dealing between the parties. So what they'll do is they will provide some statements, some monthly statements from the original creditor, and they're saying, look, judge, there were purchases and payments over several months. And they say, because of that, we can determine that, look, credit card company was offering credit, consumer was using it. Not only that, they were paying it. And so clearly they assented to the terms of what's ever in these statements. So they try to prove their case through this, like I said, course of dealing over time. The biggest issue I see with most account stated claims from junk debt buyers is they don't have a lot of monthly statements. They have usually what they call the charge-off statement, which is like the very last statement that was ever created. And then usually for some reason, they have like one more statement or a couple more from like a year or two before. The first thing I do, if account stated is the issue, I go and look at the statements that they provided and look to see, were there actually any charges or payments? Because I'm surprised that more often than not, there isn't. The charge-off statement's not going to have any charges or payments on it because it's just showing what they're claiming the balance is. And then usually the random statement that they chose from a year ago or a year prior to the charge-off statement, usually the account was already in default. So there's no payments and there's no charges. If there's no payments and there's no charges, there can't be account stated claim. They can't prove it. They can't prove that you assented to those terms because there's no payments. Or even if there's like one payment, if the balance is $9,000 and they're showing a $35 payment made once, from one monthly statement, and the credit card had been open for 12 years or something, that's not a course of dealing between the parties. So that's what those are the defenses that I bring up, is that they've got to provide more statements. They've got to be providing, and I'm not out there requesting it. Again, it's the burden's on them to prove it. If they're going to come with just two stupid statements that don't show payments and purchases, don't bring an account stated claim, because it's you should be able to defeat that. So, all right, let's see here. Go back to lifestyle. Said, is it best to call the creditor that's suing you for arbitration or write them if they sent you a summons? If you are, I like written communication just because there's a paper trail, but at the same point, I can tell you that the world doesn't work that great. When I say paper, I mean email as well. But sometimes, particularly with big companies and even debt collection firms, it's throwing a pebble into the Grand Canyon. No one notices. And so if you want to get some kind of movement, sometimes you actually just have to give them a call. So, all righty. I think that'll do it for today. We've actually gone quite a bit over, but hey, thank you for everyone who supported the channel. Again, go over to the top on the YouTube channel, the top there. I'll put a link down to after we close out tonight. And sign up for the community. We're going to be doing that training on Monday. If you're dealing with a debt collection case, this is going to be prime stuff. This is my bread and butter. This is how I make my money, is by fighting these hearsay documents, rules of evidence. I'm going to walk you through how you do that in both the summary judgment context and in trial context. And then a week later, we'll be doing cross-examination, show you how to do that, which is beneficial, not only with debt collection, but in life in general, knowing how to how to cross-examine people. But hey, I appreciate everybody checking in tonight, and we